Okay, so very warm welcome to the Wills, Inheritance and Succession Planning presentation. In the next 30 minutes, you'll learn all you need to know about this subject. My name is Carl Turner. I'm the co-founder of Expat Tax Thailand. We're here to help individuals understand their Thai tax filing obligations, understand the rules so they can make better informed decisions. We're here to help. We're a fully licensed accountancy and succession planning company. We've helped thousands of expats nationwide file their taxes. We've got over 500 five-star reviews on Google, and we're authorized and regulated by TFAC, which is the Thai Federation of Accounting Professions. All the accountants and tax consultants, the English-speaking Thai nationals with decades of experience. So our core business is Thai tax filing and Thai tax assessment. If you do need to file taxes, then feel free to view our website. Delighted to be joined today by Neil Chadwick. He's the head of technical services for IFGL Group and MD for IFGL Global Trusts. So he's got over 20 years experience in the industry, assisting advisors in tax and trust planning and solutions for clients. He's also the former chair of the Isle of Man Insurance Association and director of the Isle of Man branch of the Society of Trust and Estate Practitioners. So welcome, Neil. Thanks for joining.
Thanks, Carl.
Yeah. If there's a lot of information here, so if you've got any questions about your own situation, feel free to arrange a free consultation with one of our English-speaking consultants. We're happy to speak on a video call or phone call and answer any questions that you've got. So today, what we'll go through is what happens if something happens to you, a grim subject, but it's life. What if you die without a will or a valid will? And what are the common problems that we see again and again? Sadly, we get quite a lot of calls from clients' partners and wives who've passed away. And quite often, we've had two in the last couple of weeks where wives call to say, what do we do? What are the next steps? And to be honest, we've dealt with them not for their estate planning, but for the taxes. So we're starting from scratch. They don't know where the will is. They don't have any details. We're acting like a detective for their usually husband's estate. So, that's why we've put this together to help people understand the problems that we see, every week on a regular basis, and try and help people understand the basics and go through this. So key thing really is to go through what would happen and get people to think about what happens if something happened to you today. Does your spouse, partner, children, beneficiaries, do they know where your will is? Do they know where your assets are based, the assets that are in Thailand or overseas? What about all of your online platform banks where you don't get any statements and they won't be able to find the record? Do they know how to access any of these? Is it all down with the will? Do they know where the will is? Do your executors know that you want them to help with the process? Where are they based? Are they in the same location as your assets and the beneficiaries? Are they willing to actually deal with this? So we've dealt with quite a few cases where the executors are 5,000 miles away, and it's very difficult to deal with the estate across multiple jurisdictions. So there's a lot of questions. So I thought it's really good to have a Neil on to explain, what are the common things that you see, Neil, regarding wills and estates? What are the common problems that you see with this when someone actually initially passes away?
The problem that we see all too frequently is that a client may have been really savvy, really known exactly what they want to do, when they want to do it, where everything is, like you said, assets in multiple jurisdictions, and all of that's fine. They've got control over it. They know what's going on. Unfortunately, whenever they pass away, 9 times out of 10, probably more, their family have not got a clue. The deceased hasn't put in place any form of a succession plan. And that means that the whole process can just turn into an absolute train smash and nightmare for the family to have to try and navigate through all of that process, particularly if you've got assets in multiple jurisdictions where you aren't just going to follow one legal system in terms of being able to access those assets. After you've gone through a lengthy probate process in your home country to decide who your executors are, of course, if there's no will been in place. But it can just be a real mess, and there are lots of things that you can do to make things really simple for your family to be able to, pick up the pieces whenever a person passes away and know exactly what they need to do and why they need to do it.
Right, right. I mean, what's an example, Neil, for time frames? Let's say multiple jurisdictions, so they've got assets dotted around, like some in Hong Kong, Singapore, US, Europe, Isle of Man, some in Thailand. What's the time frame that you've seen for this to be unwound? Like a good amount of time if they've not got things set up with
Well,
beneficiaries and trusts, and a nightmare situation. What have you seen with this?
So I'll give you a couple of examples. So a straightforward example where a person's got a will, their estate's relatively straightforward, and let's say they've got assets in the Isle of Man. So the expectation will be that if everybody knows what they're doing, you've got the executors can deal with the estate in the home country, and then they can approach a lawyer in, let's say, the Isle of Man to go through the probate process there. There's a valid will in place. Say everybody knows what they're doing, what their expectations are. That process could probably be completed well within 6 months' time. I think that's kind of what you're looking at for a relatively straightforward process. 6 months, sometimes significantly faster than that. It really does depend on how complex the affairs of the individual were in their own country, what wills they've got in place, what assets there are, etc. But as far as a relatively straightforward case is concerned, 6 weeks to maybe 6 months at the outside, you would have that dealt with. However, if that isn't the case, it can be significantly longer. And I'll give you an example. So one of the businesses within our group provides life assurance contracts. So people take them out for a variety of reasons. It could be to cover mortgages, or it could be typically to leave a lump sum and some kind of financial protection for your family whenever you pass away. This particular client wasn't very old. They were in their 40s. They were involved in a terrible accident, and as a result, the claim process started. They didn't leave a will. They'd been remarried. They had children to their former spouse, and as you find in these types of cases, whenever you've got potential conflicts within the family environment, it gets very, very messy. Long story short, it took nearly 10 years for us to be in the position where we could pay that claim away because there weren't wills, there were no executors appointed. You had conflict between current and former spouses, children, who should be the rightful claimant, etc. And all of this had to go through a long and lengthy legal process in their home country before any approach at all could be made to the Isle of Man court in order for us to pay the proceeds of that life assurance policy away. So, it's quite an extreme example, but it does happen, and it happens more frequently than we would like to see.
Right, yeah. I think especially for a lot of clients that are living in Thailand, if they've got second families and kids from different marriages, if that's the case, then it can get really messy if they haven't got the right documentation. Yeah. Yeah, thanks for that. So, I mean, let's go on to the next subject. So I think dying intestate. So what does it actually mean? It means dying without a will. So, Neil, it might be good just to explain, if someone doesn't die without a proper will, what I've done is just put together what the rules are for different countries, just to explain this. But it might be good just to give a bit of an overview. That for dying without a will, the main problem is you follow the rules for the individual countries, right? Rather than what you wish. think that's the key
Yeah,
point, isn't it?
exactly. Yeah, every country. So wherever you are most closely connected, will typically determine, how your estate needs to kind of devolve to your beneficiaries or to your family. So typically it's called intestate succession. So what are the rules in that country which determine who gets what and when they get it. And it can be quite different in lots of jurisdictions. There can be different percentages that will pass down to family members. Some family members may or may not be excluded, depending on what the jurisdiction would be. So, the last thing you really want is for your estate to devolve through intestate succession. It's far better to have, at the very least, a will in place, which will cover, what you want to happen to those assets, rather than it being left to a legal system.
Yeah, I think that's the case as well. If you've got a partner rather than a spouse, or you've got children or pets, very important that you have a will, because otherwise, they might not get anything, let alone what the amount that you wish them to receive.
Yeah, I
So
mean
let's
that's it. I mean,
sorry, Neil.
some jurisdictions will recognise relationships like civil partners, common law spouses, but some don't. So you can't rely on every jurisdiction applying the same set of rules, because that's not the case.
Right, yeah. So let's go through Thailand. So if someone dies without a will, the assets are frozen, which is the same for all jurisdictions really, but the distribution goes from spouse gets half of the assets and the remainder gets shared with their children. If they haven't got children, it can go to the parents or the siblings. So that's the problem. If you don't have a will in Thailand, it's distributed by how the courts decide. And children can go into care as well if you've got children. So it can get quite messy quite quickly. And, foreigners have got a lot of messing around to do if they don't have an executor in Thailand to translate documents and deal with this through the court system. So it'd be good to go through other countries and how this applies. It's similar for other countries. So UK, if you don't have a will and you're a UK domicile, then the spouse gets the first £322,000 and the personal items, and then 50% of the rest. And then the children receive the remaining 50%. But yeah, if you've got unmarried partners or stepchildren, it can become a real mess right quite quickly. And US, there's difference between different states. I won't go into too much detail, but the point is assets can be distributed to spouse and stepchildren different for different states. So it can get really messy depending where you're from in the US as well. Same in Australia. So spouses can get all of the estate in certain states, but not in other states where it would be split between children. So it's really important that you have a will. Same Switzerland, obviously, there's a set rules for how it's split between spouse and children. So it's really important if you don't have a will, is that really what you wish it to be distributed as per these different countries? Yeah, so even if you do have a will, I think it's really important that one, you make sure that it is valid and it's witnessed properly, because that's a common issue as well. People have a will, but it's not valid and it doesn't qualify in Thailand as a valid will. And then also, are they up to date? And there's some stats from the US that 12% of all wills that are written aren't valid or up to date. So it's good to revisit this, especially if your circumstances have changed quite dramatically. That you've had children, you've been divorced, changed the assets considerably on what you're holding. It's important to update this will. Does your will contain the assets, all your overseas assets, the Thai assets, and more now it's digital assets? Are they all on the will? Because the problem what we have, so I had a case in Thailand where client died. I dealt with the spouse. We only dealt with them for the tax side of things. Went to visit them. the wife to go through this. He died suddenly, and we had to go through his laptop to try and find his bank assets and look through his history on there to try and find the assets because she didn't have a clue. And that's the problem is if it's not all written down and they're not all on there, there'll be assets that are lost, and no one's going to contact to say, yeah, it's really difficult to find. So also, if people have got children, pets, it's important who's going to be the guardian and the temporary guardian as well. So the problem, if you don't have a temporary guardian on there, then children, Thailand and Hong Kong can go into care. Are two jurisdictions that I know quite well for this. So they can be taken by the state. So it's important to just have a temporary guardian as well before the actual guardian can take over as well. And also we've had situations where if you don't have something stated where you want to be cremated or buried, you can be sent back to your home country and they can build the estate. So that can be a mess as well. And then also the executor, I think it's important that if you do have a will, do they know, are they actually willing to deal with this? I've got a friend in Thailand and he's the executor for his brother's estate. His brother's back in Europe. He had to fly over there to deal with this, and it was an absolute pain for him to deal with it. And he didn't know. So it's important that, you make sure the executors know as well. And then one of the most important parts is what you've set, is it efficient for inheritance tax for Thailand or any other jurisdiction? Is it set up efficiently so that if something happened, you can minimize these inheritance taxes that you may potentially be able to avoid? So I don't know if you've got any comments on any of this, Neil, for people who do have a will, what they should include and how it should be written.
Well, I think you've got to look at the different kind of legal systems where you've got assets that you want it to cover to make sure it's valid and it's going to be accepted by that jurisdiction. In terms of you having to go through a local probate process, some jurisdictions will accept foreign wills, some may not. So you've got to do your research to make sure that you're fully aware as to whether or not you can have one will or whether you may need multiple wills to cover different jurisdictions. You mentioned a very good point there around don't just appoint people as executors and expect them that they're going to act for you. Under a number of different jurisdictions, lay executors, so just normal people as executors, are typically not able to charge for their services. If you appoint a professional person, then they will be able to. But if you're just going to appoint your brother or your sister or somebody like that, they may not be able to cover their expenses, and as a result, that they may not wish to act. Your example there before, where your friend's brother he's passed away and he's got to fly 5,000 miles to be able to deal with an estate in another jurisdiction. If somebody hasn't got the money and or the ability to take time off to do that, then they may not wish to act, and in which case then the court will then have to appoint executors who may be significantly less familiar in terms of what the deceased actually wanted to happen.
Right. Yeah. Yeah. Very important. So I thought it'd be good just to go through some of the common problems that I've seen with wills and estates, and some things that I think a lot of people don't really think about as well. It's not top of people's mind to look at, but when we deal with it on a regular basis, we do see this. So let's focus on Thailand for a few issues. There's two separate areas that we see again and again. One is if they're an expat and they own a villa, like a house in a company structure. So if they've bought land in a company structure, is that named on the will? And is this set up properly so that it can be distributed? A lot of the times it's not. And the other side as well is if you have an expat and they're married to a Thai spouse and the assets are in the Thai spouse's name, has the Thai spouse got a will so that one, they will receive some of the assets or all of the assets on death? And two, is there a plan in place? Because obviously you can't own the land. So if they die and even if you are to be the beneficiary, have you got a plan in place for you to be able to keep the asset or receive the payment from the asset from there? Because we've seen quite a few disputes with this as well because they haven't had a will. And then they follow the intestate rules, the spouse does, and they've not been able to stay in the house. And especially if you've got a partner as well, type partner, and you bought assets in their name, it's very, very important. So let's go through the villa area. So if someone dies and they have a house in a company structure, company shares are frozen straight away. Type probate's required to be able to release this. And if you've got nominee shareholders, there's a lot of information about this in the news, in the media, that are going to clamp down on these nominee shareholders. It's really important that they might not cooperate. So if you've not got it set up properly, or you're the sole director and then they pass away, it can mean the company become inactive. It can get, if they don't file properly with DBD, the company can get closed down as well, and they can take the assets as well. So it's really important that there's a plan in place for that, and make sure that it's written properly in the will. One of the other problems that we see on a regular basis, might be good for Neil to explain in more detail as an expert on this, is if you own US equity shares as a non-resident alien. Let's explain what that actually means. It means that, say you've got a trading platform, if one of the common ones to use, like Swissquote, Interactive Brokers, any of the trading accounts or platforms, or through your bank, if you're holding US equities and you pass away and you're a non-US national, then it can become quite messy. Neil, is that right? If you're holding as an individual.
Yeah, correct. As an individual, an area that people are not really familiar with is whether or not, if they own assets which are very closely aligned to another jurisdiction. So your example here, US equities, so Coca-Cola, Alphabet shares, whatever they might be, tied to the US, then you've got to look at the legal system that sits around how your estate is able to access those assets, and also whether or not there are any tax consequences that could arise in terms of your ownership of them individually. So the US has got something called estate duty. And if you are fortunate enough to live in a jurisdiction that's got a comprehensive double taxation agreement, so DTA, with the US, then your estate might be able to offset some or all of that estate duty through the allowances that you may get. However, quite a lot of jurisdictions don't have comprehensive double taxation agreements with the US, which means that if they've got, let's say, Coca-Cola shares worth more than $60,000, then depending on the value, there's a US estate duty liability anywhere between 18 and 40% on the excess of that. It's quite significant. And it's not just the tax. The tax is just one proportion of it. It's how will your estate actually get access to those shares if they're on let's say, a platform somewhere. And typically, the estate would need to go through a US probate process, maybe IRS clearance program, before the estate will even be able to get access to those assets. So it could be a really complex set of affairs that you need to deal with. And there are some quite simple solutions that you can do to mitigate all of that, such as having the shares not in your name, in a different type of asset structure, whereby your death isn't going to influence the ownership of those actual equities.
Yeah, good. Yeah, it's good there's some solutions. I mean, so I think the point is there's quite a lot of countries that don't have this treaty protection with the US, right? I think one of the main problems is now with the new UK non-domicile rule. So 10 years or more outside of the UK, then you're a non-dom. So for Brits, that can be a mess, and then there's other countries, right? India, Malaysia, Singapore, Hong Kong, Russia, Brazil, Mexico, Turkey, China. So if you're from any of those countries, again, there's no US treaty on death. So these could all have potential for tax on US equities over $60,000. Is that right? Is that right, Neil?
It is, one of the I guess one of the main ones jumping off the slide there will be the UK. The UK does have a comprehensive double taxation agreement with the US. So if you are what was formerly known as domiciled, now known as a long-term resident of the UK, then your estate would be able to claim treaty relief, demonstrate that treaty relief to the US, and effectively we have a $12 million plus exemption on the value of US assets. So that, that's probably more than enough to cover most people. However, that the ability to use treaty relief was linked to domicile. That's now linked to being deemed to be a long-term resident of the UK. So if you've been outside now of the UK for 10 years or more, you're viewed as being a non-long-term resident. And therefore, there's some doubt now as to whether or not you'd be able to claim, or rather your estate would be able to claim treaty relief and offset any US estate duty liability. So, there's a real need to look into that if you've got concerns over your actual residence position.
Right. Basically, how you hold these shares through a different type of structure, I guess. That's key.
Yeah, it is. It is. It's whether or not they're deemed to be in your personal ownership anymore. So some things like platforms, for example, typically you'd have a look through to the individual, therefore they deem to be in their own ownership. Other types of asset structures, such as insurance contracts, for example, then you've got a degree of separation there because the insurance company would own the assets rather than the individual, and that can help in these types of scenarios.
Right. Yeah, great. I mean, so there's a lot to go through with this, isn't there? Yeah, it was good to, there's a fair bit to go to. So, I mean, how can we help? We can help really, first of all, with a 15-minute free consultation just to discuss your own situation and see if there are any questions that you have initially. What we can help with is succession planning reports and then assess your inheritance tax risk for how you want your assets distributed. Then there's a potential if you do need to write your wills or rewrite your wills, then we do have a professional executor service as well, and digital asset planning. So more and more people are holding digital assets, crypto or other assets, and they need a plan to be able to distribute these on death if something were to happen. And what we can help is the ongoing support with beneficiaries here in Thailand or overseas. So it's important. These are the areas that we can help with. So if, first of all, I recommend that people arrange a 15-minute consultation to go through their own situation. But if they do think it's worthwhile having a more deep dive, what we offer is a 90-minute consultation, paid consultation split between 2 sessions. So first 45 minutes, discovery session. So go through exactly what you want to achieve, where the assets are based and what you've currently got set up, and then arrange another call as the follow-up to go through how you would like, we'll go through the report for what are the risks with your current situation, what are there any tax traps or problems with your planning, like Neil mentioned with the equity side of things. There are other things like this that are important to go through, especially if you've got assets in a company structure like in Thailand, or for example, a spouse holding assets. It's important that you go through this in detail. We can assess current plans and wills, but that doesn't include will writing. So that's a separate service. So this is a consultation to review your own situation and put together an assessment on your planning. Once we've done this, we'll put together the report analysis, send that out with the important documents file, so you can store everything in one place, digitally and physically if you want a physical. And then also we'll put together the break glass in case of emergency document. So this is just one document that you can inform your beneficiaries or spouse just to view, and that will have all the contact details and the steps and plan what they need to do if something happens. So we put this together because we see it on a regular basis. They contact us to say, what do we do? And then we have to start going through the process of digging through their assets and whatever else. So that's what they get with this is the document so that they can really help, you know, in that worst case scenario for this to go through. Additional services, will writing, if it's found that you do need a will. The will writing part's the easy part. The difficult part is planning where things should be distributed and actually understanding the dynamics. For expats that live in overseas, it's usually a lot more complex than a normal situation if you're in your home country. So after that's been assessed, then okay, the will writing is a potential that we can help with. Professional executor service, very important. We help administer executor on wills. If something happens, then we can help distribute the assets as per the intention. We can restore the wills. We have an online document so that the beneficiaries can access that as well in the future. And, you know, we can actually store the wills as well here. So that if you do have a Thai spouse, we can deal with them in Thai at our office. And they've got a point of contact anytime in the future to help with this. If they've got overseas beneficiaries, obviously our office are well equipped to deal with those as well. So yeah, I recommend to get on the phone with us. And then we've also got a succession planning guide that might be quite useful to download. If you've got any questions, feel free to get in touch. Because we are here to help. So I think the key is we've got quite a few questions that have come in live, but some of them are coming by email. So let's go through some of these now. First one, how can I name my Thai wife as beneficiary for funds that remain in my 3 Thai bank accounts? Can I write my own will in English as long as I sign it in front of a reputable witness? How can I name someone to be the executor for my will and be sure that my will be handled properly under Thai law? So a very simple situation. If you've only got 3 Thai bank accounts and not many other assets in Thailand, then in Thailand, you don't have to have a will signed by a lawyer. You can write your own will as long as you meet the criteria. So you have it witnessed and stored. So you can do that. As long as it's in Thai as well, you can keep that will, if it's simple, on then and put the executors on there. It's more beneficial if you do get this checked by a will writer, succession planning company or lawyer, and to get them to sign off on this as well. But the reality is, yes, if it's a simple case, you could do that yourself. Just got to make sure that you meet the criteria and you don't invalidate other wills or and you make sure that you do it properly. So my last will was created and certified a notary in Germany. Here in Thailand, I had it translated into Thai, certified by the German embassy, and again certified from the Royal Thai Ministry of Foreign Affairs. To the best of my knowledge, my will is legalized in the Thai law system. I did my best to determine my Thai spouse as my universal sole heir. Is there anything else you'd recommend me to do in addition to secure my spouse even more solid after my death? No, I think this is really good planning, and you've gone through all the steps that are really needed for this. The important part is it might be good for you to have done this, but it'd be good to have a document for your spouse to understand what they need to do and the next steps, other than just being the document form. But yeah, apart from that, I think that's a good process what you've done on there. If you have no UK assets except pensions and offshore investments funds, do you need a will in Thai and English? In Thailand, only bank accounts, car, fixtures and fittings, but no property. So in an ideal world, doesn't matter UK or any other country, in an ideal scenario, you have a Thai will that mentions the Thai assets, and then you have an overseas will as well for the overseas assets in each jurisdiction, and that they both complement each other and they don't invalidate the other one. For things like the pension, Neil, you could have beneficiaries announced on there, so it doesn't have to be part of the will. And for the offshore investments, it could be possible to have a trust on there as well, Neil, right? So it might not form part of an overseas, might not be needed for an overseas will. Is that right, Neil?
That's correct. So typically with pension funds, the individual, the member will have nominated a beneficiary or beneficiaries to receive some or all of the pension pot. However, as a word of caution, the pension company won't blindly just pay away on the basis of that will. They'll send out questionnaires to determine who was there a will in place, have a look at who the beneficiaries of the will are, compare that against the nomination of beneficiary forms that they've got, because they need to make sure that, let's say that the individual had minor children, for example, that the minor children are going to be able or have got the potential to be able to benefit and aren't going to be disadvantaged as opposed to taking a different form of action. So it's really important that you still have all of the bases covered in terms of, like you've just said, Carl, if you're leaving instructions, they need to be complementary and they don't need to, detract from what another will somewhere else is trying to do. So if they're all kind of pulling in the same direction, it really makes things easier for companies whenever they're looking at assets and determining, who should actually inherit them. For other types of investments, then, you've got the ability to look at very simple types of trust structures that can make sure that they don't go through a local probate process or a foreign probate process. And those structures will enable the right people to get control of those assets at the right time.
Right. Yeah, makes sense. And then also, what about things like letter of wishes, Neil? Are these legally binding if you put together a letter of wishes, or is this just for like insurance companies, investment companies they don't have to honor it, right? Or how does this work with letter of wishes? We get a lot of questions about this.
Yeah, I mean, if you've got a very straightforward, let's say, nomination that you make to the investment company, which says, on my death, I would like you to do this, that's fine. But depending on the jurisdiction, they may or may not be legally binding or compel the investment company to actually do something. In particular, what we find now, certainly in our own experience, is that people's lives are a lot more public now because of social media. So typically, let's say a customer passed away, their spouse or their children may contact us to say, we're the rightful claimant, and we go through that process now to demonstrate that they were. Now it can be multiple different claimants, and they could all have different requirements. And when you get in that situation, unless you've got something which is legally bulletproof in that jurisdiction, then you may or may not pay out to those people. You may, enforce that it has to go through a local probate process so that at least you've got some protection from the courts if you pay the wrong people.
Right. Yeah. Yeah, makes sense. It can get really messy, I imagine, because I assume the investment companies and insurance companies, pension companies, they have the liability as well if they pay it out incorrectly. So I guess that's why it can take so long sometimes, because if there isn't a valid will or the relying on this letter of wishes, I assume that the due diligence you've got to do as a company is quite intense, because obviously that's a liability for the company as well, isn't it? I assume.
Yeah, it's absolutely huge, and as I say, when you've got multiple jurisdictions involved, it's very complicated. And that the last thing any company is going to do is unknowingly pay the wrong people, because if they pay the wrong people and a more rightful claimant comes out of the woodwork and then goes through a process in that jurisdiction through the courts, then that company have got to pay the money away. And there's no surprises for guessing that if you ask the wrong people for the money back, the chances are they haven't got it or they won't engage with you. So
Right.
that's
Yeah.
why, unless you've put the right structures for succession planning, etc., in place, you can be looking at a long process before the estate can get hold of those funds.
Right. Right. Yeah, makes sense. One question here. Have a will which is structured such that my residual estate passes into a trust. Within this, I intend for my partner, who would be a Thai tax resident, to take an income from the trust following my death. Would this be considered inheritance or income for tax purposes? So if you have an estate and you have this distributed into a trust, then if the assets are then distributed from the trust, I mean, need to see more detail, but in general, if the assets are paid into a trust and you have a Thai tax resident and then they receive an income from the trust, then it would be income from a trust rather than being inheritance, because the inheritance has been paid into the trust. So Thailand and trusts are rather different to Australia, US, UK, in terms of that, if you do have assets distributed from the trust, it is income for Thai tax residents. Yeah, so you can have it paid out like this. But yeah, that's the implication. Does that make sense, Neil, that explanation?
Yeah, it does. You've got to look at each jurisdiction's, not every jurisdiction is going to look at the actual source of the funds. So if those funds could have devolved to you directly, would they treat them in the same way as if you received them over a longer period of time from a trust structure? That's not always the case. It's very, very jurisdictional specific.
Yeah.
So you do need to keep on top of that and make sure that you're fully aware of the structures that you're creating have got the intended outcomes.
Yeah. Yeah. So it's important. That's why I think it's really important before you write the will is to do the assessment. What would you like to happen and when? So for example, a lot of, including my situation, if you have spouse and, if something happened to me, for example, and all my assets are disinvested and then paid as a lump sum to my spouse, I think it'd be an absolute disaster. It'd be a worse situation to have because I think there'd be mismanagement from assets. I think it'd be a stress and burden. So I think that's another thing to consider is with the will is to make sure, how do you want the assets to be distributed? Would you like it to be for your investments to carry on and have an income paid out to your spouse or your beneficiaries? These sort of things you can structure into the will and through the investment types of structures rather than being paid out direct to an individual or put into a trust and then paid out. You've got to really go into this, Neil. There's a lot of things that people can do, isn't there, so that the family or beneficiaries can receive an income rather than getting a lump sum and then starting from scratch.
Yeah, I mean, lots of people don't realize, how flexible a lot of investment platforms and products can actually be, or other things for that matter. And it's really important that they kind of, as you said before, sit down and set out exactly what their objectives could be, because it's far easier to change something during your lifetime than it is for your estate to try and change it after you've passed away. Lots of investment types of products can be set up with joint owners, for example, which means that they wouldn't have to go through a probate process. The assets would just pass over to the survivor on the first person's death, and then the survivor could be able to receive an income over a long period of time from those types of assets without everything having to be cashed in and then paid away as a lump sum, which, as you said before, Carl, can create a burden. And unless people know exactly what they're doing, it becomes quite onerous position for them to be in.
Right. Yeah. Yeah, it makes sense. So should we go through some of the questions that have come in live? Let me just what I'll do is I'll add them onto the screen so it's easy rather than me just reading out. Let's have a look. Right. Let's put them in here. So how long does probate take in Thailand? Will my wife have access to my account or do I need to set up a joint account? Currently, I pay housekeeping into her account monthly, but if I give her access to more, she will just spend it. Okay, that answered the question, what we've just gone through then. Probate, it depends. So it depends how simple the situation is, how proactive the executors are to deal with this as well, and what kind of assets that they've got as well for how long this can be paid out. Minimums a couple of months, and this can drag on, like Neil said with the example, Well, that's an extreme example, but it can take years for things to be distributed. If it's a bank account, if one of them dies, then it should actually be frozen, right, Neil? Shouldn't really be accessing the account if it's a joint bank account. So is that right? That's right, Neil, for
Yeah, typically most jurisdictions, then once the owner of that account that they know that they've passed away, then that account is effectively locked down, and there's absolutely nothing that can happen um, unless there's some kind of hardship kind of legislation in place in a jurisdiction where the family who are suffering on hardship for whatever reasons because they can't access those funds. But normally it's locked down until you've gone through a probate process with nobody able to access it.
Yeah, so it's important that you plan for this specifically. One question here. My children are not Thai citizens. Can they inherit my business here? Yeah, you can have it in the will so that they can receive the shares for your shareholdings. It depends on what kind of business that you hold as well. It depends on your nationality as well and how the business is structured because they can't own, if it's a Thai company and they're non-US, sorry, non-Thai nationals, they can only own 49% of the overall business. So you've got to be careful with those rules as well. It's important that you plan, but yes, they can inherit the shares. So does Thailand recognize a will executors from a foreign country, specifically Australia? Yes, they can recognize, but you'll need to get the will document translated and notarized and then signed off by the court that this is acceptable for the asset. So that can be a long, drawn out process. It's probably easier to have the Thai assets with a Thai will specifically, and then mention on both wills of each other so that they don't invalidate each other. One question here about, can you have an executor in the US for US assets and another executor in Thailand for the other assets? Yeah, you can. You can have one, if you've got two different wills, you can have different executors for different types of assets. Do you need to register your will in Thailand? You don't need to register the will. You just need, you don't actually need to register the will itself. No. Okay. My spouse is not Thai. Can they inherit our home in Thailand, or do we need to set up a trust? Yeah, I'd have to know a bit more information for this. If you are Thai and your spouse is not Thai and something happened to yourself, it could cause a problem if it is a land that they are inheriting because they won't be allowed to own that. So it's important to have a conversation if that is the case. Don't think trusts would fix that problem. There might be another ownership structure for the property that might be more suitable. But yeah, that's a very common issue that we have. Different reversal. Usually, what we deal with is expats with Thai spouses and the assets are in the Thai spouse's name. But yeah, this example is exactly the same. This could be the case, yeah. So important that you go through that in detail because it could be a problem. Let's go through a few more. Okay, yeah, this is a good question. If I'm happy for my Thai wife to get everything in Thailand, is there any need to get a Thai will? I have one for assets in my home country that directs how to split those assets. So the key is fine if you want to rely on the intestate rules, but it will slow things down and you've got to go to the court and there's a lot more messing around than if you have a valid Thai will for the Thai assets. So you could use that as a strategy, but it's probably better just to have have it noted down on the Thai will. Look at any more questions. My kids live in the UK and are British. Can I leave my Thai property to them? So it's the same question as earlier. Same question earlier. It depends how the property's held. They could inherit the shares if it's in a company structure potentially. If they don't have a Thai passport, they can't own the land. So yeah, it depends what kind of property you have as well. Yeah, very important to go through that. Quite a few questions on property. I recommend a quick 15-minute call with one of our colleagues. We can go through that in a bit more detail. Need a bit more detail, to be honest. What about crypto? Quite a lot of crypto stored in a cold wallet, and I don't want to move to an exchange, but my wife is not tech savvy. How do I ensure she receives my Bitcoin? If I die, I lose sleep over this. So I think this is very important. In my opinion, what that break glass in case of emergency documents for is, you could actually mention how you store the assets, what are the seed phrases. You could actually keep this somewhere safe and give them a plan or strategy if that's the case, that you don't want to keep it on a custodian exchange and you want to keep that on cold storage, because it's a real issue for people. If they might be savvy, exactly what Neil mentioned about assets that they store, but if you don't, then it could be a substantial amount of money that could be lost on there. And also, if people have got cold storage, we've dealt with this in the past when they do pass away, is if you don't have a valid, where did these assets come from on the cold storage unit? So when we've moved assets from someone that died, we passed assets on to their daughter, and they had a substantial amount of crypto assets. The problem, what we had to pay a crypto forensic accountant to go through the wallets to find out where this had from. It cost over $1 million baht to do that, because they'd not, it wasn't a clear trail of where these assets had come from. And the anti-money laundering rules for paying out estates into Europe now are pretty strict. So it's important not just how the access, where's the paper trail, where they're from. And this will become more and more of an issue, won't it, Neil? I think in the future.
It will, and we've come across customers in the same way, where they've got millions of dollars in crypto, and something's happened to them, and they've lost the ability to be able to access wherever it's stored, and it can just be an absolute nightmare. So you've really got to think about the people that are coming after you and having to pick up the pieces in terms of being able to access those funds, wherever they may be and wherever they may be, to ensure they can get to whoever you want to benefit in the most seamless way possible. Because like I said before at the start of the presentation, you may know exactly what you're doing, but other people will not be as savvy as you and have no clue in terms of where to even start with looking at what even is a cold wallet, for example. People will not know that.
Yeah. I think that's really when a professional executor makes sense, and then finding one that's used to dealing with crypto assets, and if that's the case for people, or it's really important that you get that done, because I think we've dealt with two recently with crypto estates. I think there's 20%, 30%. I think there's assets that we can't find, to be quite honest, that have just been lost. Going through hard drives and trying to find assets is time consuming, expensive, and we can't find everything, to be quite honest. So it's important that you do note that down and have a plan in place. Yeah. Any more questions? Sort of a quick look, see if there's any that have come in. All right, last question. I'm single, no family, no pets. I want to leave my money to Cancer Research UK. I have no UK will. Can I set up a Thai will for my savings upon my death to send to charity outside of Thailand? Yes, you can set up a will to have the assets to distribute it to a charity anywhere. Yes, you can. So you could set that up to be distributed to a UK charity if you wish. If you'd like to send to a Thai charity, there's plenty of good ones here as well, that you could set that up to. So yes, you can do that and have everything left to a UK charity or an overseas charity. Yeah, that's fine. Yeah, so hope you found that useful. Thank you very much, Neil, for helping with this and giving your insights into this. Very much appreciated. And for everyone joining, if you do have any questions, like I say, it's very specific to your own situation. Feel free to get in touch. Thanks, Neil.
Thank you.
Thank you. Bye-bye.